distinguished guests, judges, esteemed advocates, dedicated legal fraternity, devoted fraternity of Ramanarayanam, and dear students, it's my honor to welcome Professor Sriman D. Surya Rao Garu, the Honorable Vice Chancellor of Damodaram Sanjivayya National Law University. He is a distinguished academician with 41 years of teaching experience. He is a rare combination of academics, research, and administration. He served the Andhra University Law College in different capacities, such as Principal, Chairman, Faculty of Law, Chairman, Board of Studies in Law, Convener, Research Forum, Student Advisor, Deputy Warden, and Dean, Guest Houses of Andhra University. His expertise spans jurisprudence, constitutional law, human rights, and more. He has published over 50 articles, guided numerous PhD scholars, and received several awards for teaching and research. Sir, we welcome you to address this gathering and enlighten us with your experience.
Good afternoon to everybody. So, respected organizers, Ramanarayanam family, Justice Setirajulu garu, my mentor, and honorable judges, advocates, director of Valmiki Research Center, and student friends. Today we have a serious discussion about the relevance of ancient legal thought to the contemporary Indian society. As my earlier speakers explained the importance of the institution, its commitment and objectives, and the research center, particularly Madam Justice explained all the aspects of Ramayana and the relevance of those values to the contemporary Indian society. So I need not repeat all those things. And when Rama went to Vasishtha and knocked at the door of Vasishtha, Vasishtha asked, "Who are you?" Rama replied, "To know what I am, I came to you." That is what is Yoga Vasishtha. So, as our judges and the contemporary relevance of this ancient thought, in Keshavananda Bharati, 13 judges gave 11 judgments about to understand the concept of sovereignty. So, whether it is divisible or indivisible, or whether the accountability of the sovereignty, the functions discharged by different powers constituted under the constitution. And they referred the Ramayana concept of sovereignty, Bhishma concept of sovereignty, as well as the Western concept of sovereignty, Bodin concept of sovereignty, Austin concept of sovereignty, to understand the sovereignty under the Indian constitution. Of course, Keshavananda Bharati created the basic structure basing upon the constitutional morality. That's why at the time of the framing of the constitution, we took the relevance of different constitutions, particularly Britain Constitution, American Constitution, Irish Constitution. But the originality of the Indian Constitution to reflect the aspirations, political aspirations, economic aspirations, social aspirations of the Indians were taken into real consideration by the constitutional makers. For them, the guiding philosophy is our Upanishadic philosophy, and of course molded by the ancient Indian culture. And Asatoma Sadgamaya, Tamasoma Jyotirgamaya, Murtyorma Amrutam Gamaya. This is the essence of Vedic oneness, the Upanishadic philosophy, for which the evolution of the Indian society, or for that matter, the evolution of mankind. You know, from old Stone Age to new Stone Age. And Indus Valley civilization was flourished in India, where urban culture was there, where the copper age. And that's why our Professor Lajapathi Rai referred to the fundamental rights chapters depiction, Ramayana. Prior to that, we have Indus Valley civilization's findings. Then, for directive principles of state policy, we have Bhagavad Gita, preaching of Bhagavad Gita by Krishna to Arjuna after this particular Vishada Yoga at the time of the beginning of the Mahabharata. So then Jainism and Buddhism and all we know, Ramayana considered acceptable point was 6000 BC to or 7000 BC to 3000 BC and 2000 BC. Particularly we have early Vedic period where Rigveda was developed, then later Vedic period. So after that, the two greater epics of the Indian culture, Ramayana and Mahabharata. Of course, Mahabharata is something which is regarding the practical human life with having differences and all these things. But here, Rama is one of the human being who is considered as a model, ideal human being. One man, one word, one wife, one weapon. So that's why even Kelson pure theory, where he tried to understand the constitutional structure for a society. So here, where in Kelson pure theory itself, Hans Kelson gave an example. A school-going boy asked his father, "Why should I go to school? Because all the other students are going of your age, you should also go." Then why should all the people go? This illustration was given by Hans Kelson in his own book, where the other. So what is this? So the tradition, the culture, the civilization. Ultimately, the discussion goes to the extent of who is God, because God says we have to follow. Then the child asks the father, "Who is this God?" God is presupposition. Constitution of India is presupposition. So that God was taken by Indian culture. The model God is Rama. So when I attended one conclave regarding the comparison of these all the religions, one Islamic philosopher mentioned about Bhagavata's Gajendra Moksha's prayer of Lord Vishnu. Yavani je janinchu jagamavani lopala nundu lenammai yavani yondudindu parameshwarundevudu moola karanammevudu vaani atmabhav Ishwarani ne saranamu vedida. There is no mentioning of any particular God. So who created this world? Who controls this world? Who leads this world? For that super being I am praying. So that type of comparison. Now in the modern Indian context, we should have to understand the social realities, the political realities, the economic realities, the sovereign citizen relationship. In that context, we have Constitution of India. So for that also, the entire jurisprudence was developed in such way, law is dictate of God. Whose God? For Hindus, Hindu God. More specifically, Lord Rama. Law is dictate of nature. Law is dictate of a metaphysical concept. But ultimately, when all this modern scientific thinking challenged this type of metaphysical thought, the Immanuel Kant came. He simply implanted law is dictate of reason. So what is that reason? Reasonability. In order to understand what is reason, you have to go to Ramayana. So that reasonableness controls the judicial process, the legislative process, or the public life today. So that reason was, what is this reason? If you go to equality, reasonable classification. If you go to freedoms under Article 19, the state can impose reasonable restrictions, not unreasonable restrictions on the freedom of the people. If you go to Article 21, life and personal liberty, law should not be autocratic law. It should be a just, fair, and reasonable law. That doctrine of reasonableness, in order to understand the doctrine of reasonableness, one should go to Ramayana. One should take the life of Rama. The reason, another thing is that Madam told and others told about the importance and the idealness of the Lord Rama. Regarding three issues, Rama has to answer the people. The first one is when he was to kill Tataki, a woman demon, Rama objected. Then Vishwamitra told Rama, even though she was a woman, she is a demon, you have a right to kill the woman. Second aspect, Vali asked after being fallen, being a lord, being a human being, I heard about you lot of things, but why did you kill me behind the tree? Why shouldn't you come in front of me? Then Rama answered, if you are a human being, I have a direct fight with you. You are an animal. Animal can be killed. We are hunting the animal. So that answer was given by the interpreters of Ramayana, why Rama killed Vali while throwing the arrow while standing behind this thing. The third one is very interesting. Today also some objections were there from some challengers, the change wanted people. Shambhuka. Shambhuka was doing tapasya and Brahmin community, because Rama Rajya as dictated by Rishiprakta Dharma. So the ancient Hindu Sanskriti or Rishiprakta Dharma was followed by Rama. Varna Dharma was there. So when priestly community complained that a Sodra was doing tapasya, which was against Varnashrama Dharma, then you should do something. Rama went and cut the head of the Shambhuka while he was doing tapasya. So recent objectors of this particular thing, one poet, modern poet also wrote a poem. తెగిపడిన శంభూకుని తల ప్రశ్నిస్తుంది, విరిగిపడిన ఏకలవ్యుని వేలు వెక్కిరిస్తుంది. So in order to, we have to understand the diagnosis of the social chemistry. So how can we understand the relevance of Ramayana today in the contemporary society? We have to take the questions raised by the others also. So for all these, of course, Varna Dharma, it was there. Of course, Gandhi also talked about Ramarajya. Now we are also talking about Ramarajya. And I can remember one episode, one incident, when some communal rights were there and something was there, when state lawlessness was there in Gujarat. Vajpayee was asked, sir, what was your reaction about this? When unruly situation is arisen, then Atal Bihari Vajpayee, the then Prime Minister, commented, Chief Minister should know Rajadharma. Rama followed Rajadharma. That's why we are now remembering, recollecting. So, we came here to express our solidarity to the Ramayana philosophy. The reason is Rajadharma was in strict sense followed by Rama. So that is what is, that's why the Indian culture, the modern governance, the modern accountability is through Ramayana. So why Vajpayee said that? For king, all the subjects are common. So if you have a personal ideology, personal feeling, but once you became the king, you should protect the subjects while discharging your duty. That is what is Rajadharma, which is propagated, followed, and practiced by Lord Rama, still relevant today. And we know the modern concept of justice. Of course, we are talking about the Western jurisprudence. Law is not logic, it is human experience. And John Rawls, for justice, fairness, fair treatment, which can be experienced with the life of Lord Rama. Then your human capabilities, Martha Nussbaum understood this particular human capability theory. You can talk about human rights, but simply giving human rights is not sufficient. Overzealous human rights activists may take away the human rights, exploiting the underprivileged sections. So before human right, you should develop human capability. Right to primary education, right to primary health, right to food security. Those were assured, including your environmental justice, your natural justice principles in Ramayana. That's why we can proudly say that Ramayana is still contemporary relevant. When you have any doubt regarding any constitutional issue, regarding your personal issue, you can go and search for a solution through Ramayana. That is what is my understanding. And the constitutional morality is also framed through the Indian philosophy, ancient culture, which has been molded definitely among the Indian culture. Of course, the culture has been evolved. That's why here I have to remind Henry Maine also, who wrote a book, Ancient Law, for which he studied ancient Indian legal systems, ancient Roman legal system, ancient Greek legal system. And he came to understand that the failure of Hindu law is the success of Roman law. The reason is, for every 100 years or 200 years or 500 years, Roman law has been codified and recodified. So Justinian Code, 10 Commandments and everything were there. So the law has been changed according to the needs of the society. Unfortunately, the ancient Indian society has no that opportunity until the first stage of codification. So Henry Maine says how the law was developed by achara vyavahara, by customary practices practiced by the people. After some time, those customary practices became commands of the king. Then king made the law. Then they have to be followed. After some time, the elderly people, after their life, settlement in the early elderly life, go to Aranyakas. That's why we have Aranyakas. Aranyakas means the old people go to forest and settled there and contributed their own experience. Then Upanishads. All these were there. So that's why for the first stage, codification was correctly made in India for ancient Hindu law. Narada Smriti, Parashara Smriti, Yajnavalkya Smriti, all these. But because of the historical facts, because of the unknown factors, the Hindus had no settled life. So it was not recodified at an appropriate time. That's why social evils were incorrupted, like Sati Sahagamana, human sacrifices and all these things. But along with the Indian national movement, we have also social reform movement. So now you take Hindu Marriage Act 1955. The monogamy is the rule because of Rama. Rama's father has 350 wives, but Rama has only one wife. Rama set the life, human life, as a model. So thank you very much. I want to say several things. Thank you very much for giving me this opportunity. Thank you very much.
Thank you so much for your valuable words, sir.